the bad guy. And specifically, I represent a man who has been painted to the world as an incorrigible womanizer, criminal, fraudster, thug, scoundrel. You can call it whatever. I represent a man who, unfortunately, for lack of a better word, Honorable Chair, is the dog that has been given a bad name. But we must tell the move of this motion, we don't dismiss people from state office because they have a bad reputation, especially when that reputation is an artificial creation of a previous administration that was only doing this to punish the Honorable Linturi for supporting the candidature of the Honorable William Ruto as President of the Republic of Kenya, as opposed to the other candidature that the administration then in place preferred. What I'm trying to tell you, Honorable Chair.
May I say something? May I raise an objection?
Right. I'll allow it.
Senior Counsel, just a minute. Honorable Adwa.
No, on account of this age, you can go first.
Senior Counsel.
May I say, I'm most grateful to my current friend that he acknowledges age as being a virtue. Now, may I say this to my able current friend? We must move from this culture, which was started in current days, of keeping on mentioning the head of state in proceedings in order to get sympathy, appreciation, and respect. His Excellency William Ruto is not a party to these proceedings. We don't have to mention his name at all, so that to impress anybody. Let us move from this culture of moving of mentioning head of state. You don't get such a thing in England where people are mentioning the Queen, the proceedings of the Prime Minister, the proceedings and so on. Nobody has done anything against Linturi because he was not friendly to the previous regime headed by His Excellency Uhuru Kenyatta, or because he is close to His Excellency William Ruto. Let us strip out when mentioning them of head of state.
Thank you, Senior Counsel. Honorable Bajo.
Well, I think we need to be relevant. Even in open submissions, you must be relevant to the facts in issue. Those facts are fake fertilizers and the ones you call love and affliction or whatever they are. To get into politics, we'll be getting out of the rail. And many of these members know how to play politics than people on your side. So just come back to what is relevant and prosecute your case and finish it.
Honorable Chair, I'm guided.
Thank you very much.
I'm guided, Honorable Chair. Just for the record, I'm not saying this because it is irrelevant. Every legal dispute has a context in which it arises. And if you just allow me to finish, it will be clear why I'm mentioning this. And specifically so that we don't waste more time. All I'm trying to say, Honorable Chair, is that it is humanly possible for us to fall into the trick of saying it is that notorious Linturi. If there are serious allegations about him, they are made because they are true. And that's the only danger that I'm warning the committee about. That is the only context in which I tell you, because it is public knowledge, that the man I represent was a victim of that public shaming, public vilification campaign on TV, on whatever. I am here to humbly tell you, Honorable Chair.
I'm afraid the member has no power to warn the committee. Yeah, that's what he said. I'm warning this committee. It is not within its power.
It's a legal term, Chair. I think my colleague, when we say warning, it's not in the ordinary sense of the word. It is in the sense used to direct juries about the dangers of prejudice and the dangers of bias. So it is not a warning, of course. Honorable Linturi has no capacity to warn anyone.
Thank you.
It's a term of art and it's a legal term. I think my colleague doesn't know.
Thank you. You have educated those who are fellows, and we have.
May I say something? Let us not forget. With a serious tone. Let us not forget. He has told this select committee that he's under surveillance. So when he uses the word war, he knows what he's talking about.
Thank you. The honorable members are here.
Honorable Chair, with all the interjections now, I don't know how much of my time has been spent in the. I will ask. Okay.
We will take care of that.
Okay.
We have taken note of what you have said. Thank you.
Much obliged. So, Chair, I was saying that when you sit as a judge, because this committee is sitting as judges, the practice in the legal world, and luckily there are many legal minds in your committee, is always to one of the dangers of putting in your mind, oh, he's that bad guy. And because he's that bad guy, he must be guilty. The allegations must be true. That's all I'm doing by giving you that context. And I must also tell you, Honorable Chair, we must be dangers of the crucify him approach to a matter like the one before you. In the Christian Gospels, we were taught, because the mobs were baying for blood, crucify him, crucify him. He's a bad guy, therefore, and I'm saying again, it is easy for you to be told cries of farmers, cries of victims. And of course, we are not here to trivialize. Farmers have suffered in this matter. No one can deny that with a straight face. What happened is as unfortunate as it can get. But that would not justify a lynching or a crucify him approach to the matter before you. That is why under the Constitution, Chair, you are to investigate. Your duty is not just to roll heads, to serve somebody's head in a platter so that the masses can stop saying crucify him. We are baying for blood. Honorable Chair.
Let us be honest. Let us not waste the time of the committee. We are doing so, I'm sorry. Linturi himself has said very loudly that the farmers who received this fake fertilizer should be compensated. He has said so very loudly.
Honorable Chair, I will seek your protection because I now believe there is a strategy to interject so that my thoughts don't flow. I never talked when they were talking for a whole 40 minutes. There were many things they said that I had issues with.
Council, we are aware of all this, and senior council, you have your time, and if we keep interjecting, then you will interfere with this time. We are already, we will add some more time as a result of what we are doing. Kindly be patient because you have 40 minutes.
Thank you very much. But only one sentence.
Yes.
He did not interject because we were talking sense.
We'll leave that to the committee, Honorable Chair.
I think what we had, senior council, Minwa, and my brother here, give him time to finish because when they're also raising their issues, we kept quiet. Because I remember at one point, the mover talked of a fake minister. And we didn't raise anything. So let us allow it to proceed the way we allowed also. Sure.
Yeah, I think we have already said that.
Honorable Chair, the member is supposed to be neutral. So he's saying we didn't. I thought they are supposed to be the ones to say we. He is supposed to be a neutral actor in this thing unless he declares.
We are a neutral team.
Yeah, yes. He said we parliamentary language. We need an interject.
He is referring to us as parliamentary committee, and we meant all of us. So please let us not do a lot of interjection because that will consume a lot of his time and also interfere with the flow of his presentation. Thank you. You can resume.
Thank you, Honorable Chair. And I was saying it is because of these dangers of bias, prejudice, that our law forbids the use of character evidence, disposition evidence, similar fact evidence. Basically, all I'm saying is that this matter is not one in which we can judge Linturi for his so-called reputation. I now come to the mandate of this committee, Honorable Chair, as directed by the Speaker. The Speaker said these proceedings are quasi-judicial and they have to be characterized by heightened degrees of conscientiousness, fairness, transparency, and whatnot. My understanding, Chair, of which I could be wrong, is that this committee is sitting as judges. You're not sitting in this committee in your capacity as members of the National Assembly. You're not sitting in this committee as representatives of whatever political formation.
I think we know our role. Can he focus on what brought us here? Fake fertilizer. Honorable Omando, please.
Thank you very much, Honorable Member.
Please, there is a lot of interference.
New Garnier Vitamin C Night Serum. 10% vitamin C to help prevent dark mark reappearance.
We will make our judgment.
Point of order, Chair. I think let's go back to the basics that for the opening remarks, somebody should not be interrupted. I think that is the basics of any
That's what I'm trying
It's
to say.
unfortunate we allowed it, but I think, Chair, you need to assert that for opening remarks, there are no interruptions whatsoever. Period.
And I wonder why we are getting emotional. Please let us be patient, let us listen, let us not jump and make conclusions. And we were very fair with Honorable Wamoka and his team. So I don't see why we should, always interject when the council is presenting. Please let us be patient and give him the remaining time, please.
Thank you, Chair. I was to say you sit in this committee as judges, and the only point I wanted to highlight in this, of all the things human beings do, Honorable Chair, of all the offices human beings occupy, it is only in the office of judge that a human being takes the position of God to pass judgment on another human being. The other things we do are temporal. The administration of justice is something divine because it elevates the human being making that decision to the level of God. That is why our constitution in the third schedule, Honorable Chair, says justice is to be administered, quote unquote, without any fear, favor, affection, bias, ill will, prejudice, or any political, religious, or other influence. I'm humbly submitting to you that this is the applicable constitutional threshold. That oath of office for judges is the applicable constitutional threshold for resolving the matter before you. I'm here to very humbly tell you, Honorable Chair and Honorable Members, that justice is a two-sided coin. A coin has two sides. There must be justice for farmers, but there must also be justice for the Honorable Linturi. An injustice to Honorable Linturi cannot be justice to farmers, just like an injustice to farmers cannot be justice to Honorable Linturi. And your duty as a select committee, therefore, is to inquire into this matter using that constitutional threshold that I've just alluded to, and to decide this matter as judges without fear, favor, and all those other things that I mentioned. When you see the motion before you, there is not a single act by Linturi, there is not a single act or omission disclosed on his part. On the contrary, what is before you are alleged acts of third parties. We have placed before you in document number 2 and in document number 21 evidence that shows that Linturi is not guilty of these allegations. We are here to tell you when we get there, Honorable Chair, that this motion seeks to punish a single CS for what is the official policy of the government of Kenya. The fertilizer subsidy program is officially part of the program of the Kenya Kwanza government. The motion itself concedes this, and in fact, it states in black and white that this program, this policy, was part of the Kenya Kwanza manifesto, and it was even put to the voters in the election. How is it, therefore, Honorable Chair, that if those are the facts as pleaded by the mover, we now isolate one cabinet secretary for what is considered in the motion to be part of the official government policy and say this is the cabinet secretary who is liable for whatever went wrong with this policy? We will be asking you to check that the whole of ground 2, as I said, is matters that predate the appointment. We'll be urging you when we get there to note that the mover has lied. L-I-E, Honorable Chair. They have misrepresented one of the many family and commercial and whatever disputes in which he tells you that the Honorable Justice Omundi condemned Linturi and found him guilty of some things here and there. On the contrary, because we have produced that document before you, that judgment, we will invite you to read it. It is, I believe, at page 228 of our Badu, to ask yourself, is it true? And are we going to believe a mover who has the audacity to even lie to you on a document that is in the motion in black and white? He tells you this is what the judge decided. It's there. That's not what the judge decided. On the contrary, that ruling upheld the complaint that the Honorable Linturi addressed about the persecution by the previous administration, about the previous administration latching on to personal, family law and love matters to convert them into a tool for negative media campaign, as a tool for criminal arrest, as a tool for other forms of state-sponsored oppression. We will invite you to note at page 252, document number 10, that the matters were closed, as I told you. We will invite you through documents number 11 to 19, as I said, to note the courts, and I mentioned them, all of them, sitting in various stations, ruled in favor of Linturi. How can that material now, in which the courts ruled in favor of the Honorable Linturi, be the reason we are here? And lastly, Chair, so that I'll give my waiter at least 10 minutes, I want to come back to judging, because you're sitting here as judges, and I said judging is the only human enterprise where human beings take the seat of God and pass verdict on whether the behavior of other human beings is sinful, is criminal, is moral or immoral, and whatnot. And because it is something where we take the position of God by passing judgment, I am to reflect and ask myself, what does God teach us? Unfortunately, I'm not a religious man, and my interaction with religious texts, Honorable Chair, is sporadic and disjointed. But I tried the most I can to ask myself, what does, if we agree that judging, which is what you're doing, is the only activity in which we take the place of God? And I asked myself, from Islam, what do we learn? Because the dominant religions in Kenya are Islam and Christianity. In Islam, I checked one of the hadiths, Hadith 3566. The hadiths, Honorable Chair, are recordings of conversations the Holy Prophet is believed to have had with various actors and passed on the divine revelations to him. So this particular hadith is about judging, and it says, if I may read, judges are of three types, one of whom will go to paradise and two to hell. The one who will go to paradise is a man who knows what is right and gives judgment accordingly. But a man who knows what is right and acts tyrannically in his judgment will go to hell. And a man who gives judgment for people when he is ignorant will go to hell. It's book 24 from, I think, Hadith 3566. You know, Chair, when I say you're acting in the place of God, because that's what the law permits you to do, if you doubt that you're actually in the place of God, the decision you make, there is no legal recourse against it, just like judgments passed by God. You know, the other judgments, we go in the lower courts and whatnot, you can appeal to the High Court, appeal to the Court of Appeal, appeal all the way to the Supreme Court. Yes.
I need to notify you that you have less than 9 minutes now, together with the time that we have added. We have added 5 more minutes because of the interruption.
Can I assume you will allow my friend the 10 minutes I had craved for? Unfortunately, all the interjections now sort of mumbled up my time consciousness.
Then that would mean to conclude. And we allow
Okay, just 1 minute I conclude, then Mawera will do 10 minutes. Honorable Chair. I asked myself what we learned from the Holy Bible about judging, and we are told one of the things in Matthew 7 is let's be slow to judge, let the same measure be used to judge. Again, the same measure we use to judge others be used against us. We are told in another biblical text about judging the speck in your brother's eye and forgetting the log in your own eye. And why I ask this is the mover told you many things about the arrest of his spouse. And for me, the question is, where did he get the courage to move this motion when, as he was prosecuting it, his own spouse was defending herself in criminal proceedings for fraud? With those very many remarks, Chair, please allow me to call Mr. Mawira. And thank you very much for the time accorded to me.
Honorable Chair and the members, my name is Boniface Mawira. I will begin from what my learned senior Dr. Muthomi was alluding to, the issue of the judgment that the mover or the sponsor of this motion has referred to in allegation number 2. All these issues about love and affection. It is very unfortunate that as the Cabinet Secretary has to respond to these allegations, because from where we sit, they are really belittling of this committee, that this committee has to descend to that arena of love and affection. But because the Cabinet Secretary must respond, then we are compelled, Honorable Chair, to bring to your attention that there are 3 judgments, a judgment and 2 rulings. There are 3 judicial decisions by the courts of this republic that in all the 3 judgments, the courts, judges are found in favor of Honorable Linturi that all these allegations of uttering false documents, procuring execution of documents through false pretenses, allegations of forgery and fraud. These 3 different courts sitting in different stations in the Republic are found in his favor. And they have held in the judgment of 30th November that the mover has referred to in his motion, specifically ground 2, that the allegations of forgery, the allegations of uttering false documents, procuring false execution of documents, all those allegations are untrue. And that is why we say, Honorable Chair and the members, that the mover has seriously mischaracterized the judgment of 30th of November 2021, which we have referred to in our response. Even more importantly, Honorable Chair, you will note that ground 1E, allegation 1E in the motion, it talks about alleged gross violation of Article 152 of Article 152, 5 to 10 of the Constitution. We submit in response, Honorable Chair, that those provisions of the Constitution are incapable of breach by a Cabinet Secretary. There is no duty imposed in law on the Cabinet Secretary by Article 152 of the Constitution. Article 152 of the Constitution merely talks about the powers of the President to appoint a Cabinet Secretary, and even the powers of this committee, or even the National Assembly at large, to dismiss in the event that a motion calling for the dismissal of a Cabinet Secretary is upheld. So there is no specific duty imposed in law for the Cabinet Secretary under that constitutional provision. So it must therefore be that that constitutional provision is incapable of breach by the Cabinet Secretary. Honorable Chair, all the judgments that have been that are referred to in the motion under allegation number 2 about serious reasons to believe that the CS has committed a crime under national and international law, all those judgments that relate to this love and affection, all these judgments and all these matters that are referred to, all those court cases, they predate his appointment as CS. These are matters that were disclosed to the Committee on Appointment during the vetting of the CS. And these are matters, therefore, that could not have arisen as a result of the performance or the execution of the duties of the CS. These are matters that were there before, and the Committee on Appointments considered them in approving his nomination. Honorable Chair, my learned senior Dr. Hamino, in his opening statement, talked about the Evidence Act and the place of the Evidence Act in these proceedings. It is important that I make this clarification in order to not only to guide the committee, because we have made, in our response, in our response, Honorable Chair, there are documents that the mover in his motion has referred to, which we contend are inadmissible hearsay. And this committee, Honorable Chair, you will note, adopted rules on the 2nd of May of this year in its first sitting. And rule number 14 of those rules, Honorable Chair, says expressly that these rules shall complement the provisions of the Evidence Act. So it is not true, and in fact it is misleading for my learned senior to say that the provisions of the Evidence Act, specifically on the issue of inadmissible hearsay evidence, do not apply. This committee, in adopting its own rules, clarified and stated expressly that the provisions of the Evidence Act apply, and these rules merely complement, that is the language of the rules, they merely complement the Evidence Act. And therefore, it must be that those rules, especially on the admissibility of hearsay evidence, they must apply to these proceedings, Honorable Chair. There's another allegation, Honorable Chair, that the mover in his opening statement alluded to about Ugandan farmers sourcing and actually buying fertilizer. That is clearly meant for the Kenyan farmers. The subsidy program, Honorable Chair, you will note, for a farmer to be able to purchase fertilizer, they need to register on the Kenya Integrated Agriculture Management Information System, KIAMI system. And more than 4 million farmers have registered on that system. And the principal document for a farmer to be registered on the system is the ID card. So how is it possible then for a Ugandan farmer who is not Kenyan to acquire this fertilizer if they are not on the system? Because for you to get the fertilizer, you need to be registered on the system. Even more importantly, there is an e-voucher that is sent to your mobile phone number. So the ID is a principal document. And Ugandan farmers clearly do not have Kenyan ID cards. Honorable Chair, I think the last point for me is on the issue of evidential threshold, as my learned senior Dr. Muzomi alluded to. The Sonko case is clear that when it comes to matters of admissibility of evidence, inadmissible hearsay evidence would clearly fall short of the evidential threshold and the nexus that the Supreme Court stated is required before a resolution for removal of a state officer from office. And Honorable Chair, I would just want this Honorable Committee to take note and let the committee, because we have had in other proceedings elsewhere, before the Senate, and specifically when the Senate was debating the impeachment bill that is currently before Senate, I personally heard the majority leader of the Senate say that that bill is meant to cure or to remedy the problems that arose after Governor Sonko was unlawfully handed out of office. So let us not, Honorable Chair, fall for that mistake. My last point for me, Honorable Chair, is what my learned senior, and as we've been saying, the Honorable Member for Waldai is the real face behind this impeachment motion. And as my learned senior confirmed, he even met her yesterday evening. He met her yesterday evening and she was telling him she does not even have a child with the Honorable C.S. Linturi. Clear, what would be the motive for the council representing the sponsor to meet her if she is not the real face behind the motion? And the entire ground two, all those allegations that point to these personal, family, civil, commercial disputes are between the CS and the member for Aldai constituency. So clearly she is the face behind this motion. And that is why we're saying this motion is actuated by malice and personal vendetta. Honorable
Manuel, please let us continue because it's just about to conclude.
I want to protect the lady in question. We are talking about Linturi, not the ex.
Thank you.
Honorable Manuel, the matter was brought by the sponsor of the motion.
Thank you, Honorable Chair, for the protection. Honorable Chair, my last point for me is let us do justice. As my senior said, justice is a two-sided coin. And injustice to Linturi does not mean justice to the farmers. Justice for the farmers does not mean injustice to Linturi. Let justice be done to either party. And the CA sympathizes with the plight of Kenyan farmers. The farmers who are duped, they have suffered enough. But let justice be done for both parties. Thank you, Honorable Chair, and the Honorable Committee for listening to me.
Thank you for
Chairman, I don't know whether you may allow me one.
keeping time. Yes, 1 minute I will allow you.
Chairman, let me respectfully make a comment. I'm really not going to really deliver so much on what my friends has said. Just want to mention to remember.
Honorable Minister, Cabinet Minister, please go in front and use that.
Chair, as he's going there, on a light note, C.S. Linturi is a chairperson. It is not chairman because our chair is a lady.
Chairman, on a point of order, Chair. Chairman is a position. Can be a lady. And I'll tell you, there's a lady who was elected the chair of the Dorset Club. And she said, I will be called the chairman. That was Dr. Professor Yeko. And she remained as it doesn't have a gender orientation.
I know man stands for both, but please, because of time, let us allow the Cabinet Minister to continue.
Thank you, Chair. And Chair, let me appreciate what the committee is doing, because that's a constitutional responsibility to discharge. But I've inclined, felt that I must really say something, because Chair, whatever I've gone through for a number of years, and which is also manifesting itself here, it's not anything I would want to wish any human being. It has been a long journey, very painful. And when I thought and gone through that kind of trauma, the emotion is here with the same stories that I've been trying to fight over years. When Learned Council, Camino, tries to trivialize this matter, it pains me because it doesn't know how painful it is. Because, Chairman, there is no, in the history of the judicial system, nowhere, and this matter has ever been done or conducted live on TV. It was mine. And that was the reason when Dr. Muthoni Ankolo tries to contextualize this story, then it's not taken seriously. Just like as mentioned, there's a judgment there by Ngundi, which clearly in a paragraph says